Oh boy, so I just did that video where Midjourney made the motion that part of Disney's lawsuit against them should go down because of Cox v. Sony. If you remember that, that's a Supreme Court precedent from a few months ago, where they said that you're not liable for infringement done by your users, except in a couple of very strict scenarios. One of those is where you're actively participating or inducing the infringement by your users. And the other is if you have a service tailored to infringement, meaning that you don't have any substantial non-infringing uses of your service. Well, before Cox, what the big content cartels like Sony and Disney and all of those were saying is that you knew that your users were infringing, and that means you're guilty. You did nothing to stop them. Supreme Court said that's not enough. They said you could have filtered those users. You could have kicked them off your service. You could have done this. You could have done that. Supreme Court said, not good enough. Knowledge isn't enough. Failing to act isn't enough. And on that basis, they kicked out Sony's major lawsuit against Cox, where they got over whatever it was, $1 billion. Huge case, went on for years and years and years. So that's what Disney was saying about Midjourney. They were going over page after page. Look, Minions. Oh, look, Iron Man. Look, Midjourney can be used to make all of these things. So what? But they were claiming that Midjourney knew that people were going to use its service to infringe on their characters. But then the Supreme Court came out with Cox. And Midjourney said, well, nope, you see, Supreme Court said that's not enough. You got to kick out that part of the lawsuit, Judge. So now we have Disney's response to it, and I wasn't going to cover this one until Midjourney came out with their reply, and then I was going to cover them together like I've done a few times in the past. Just kind of makes it a little more efficient doing these videos. But oh, then I read it. And oh man, this is such a staggering fail on its own. I couldn't resist making its own video. And they are really trying to rescue this lawsuit from the jaws of Cox. So for example, here they say in Andersen v. Stability AI, which is still an ongoing lawsuit, Judge William Orrick considered similar allegations against a Gen AI service and concluded they amply supported inducement. The plaintiff artist claimed that Stable Diffusion, the defendant's AI image generator, used the plaintiff's artistic works as training images and as a result could produce output images in the style of those images. Search the channel. I've got videos on how stupid it is to say you can't copyright a style, but trying to do that would destroy art. So check that out. The court denied Stability's motion to dismiss the inducement claim, which argued the plaintiffs had not alleged that Stability engaged in advertising or other promotional efforts aimed at encouraging infringement. The court concluded that allegations that Stable Diffusion was built to a significant extent on copyrighted works, that it necessarily invokes copies or protected elements of those works in its operation, and that it outputs infringing images were enough to support a plausible inference that the product by operation by end users creates copyright infringement and was created to facilitate that infringement by design. Here's the problem. That was pre-Cox. That was before the Supreme Court came along and upset the apple cart. And Cox is very clear about what counts as inducement, and this doesn't. I mean, I don't know what Stability AI is going to do over in their lawsuit about it, if they're going to make a motion to kick that part out because of Cox or not. But regardless, they didn't have Cox at the time Judge Orrick decided this. So I don't know what they think they proved by doing that. Plaintiffs do not allege that Midjourney merely organized or passively indexed user content. Instead, plaintiffs contend Midjourney deliberately selected infringing images for public display on its Explore page and deliberately chose to display them with word-for-word recitals of prompts that instruct users on how to obtain the same outputs. Yeah, we covered the Explore page last time. Go watch that earlier video to see what that's all about. Plaintiffs object to Midjourney's improper attempt to bolster its arguments with factual material including a declaration purporting to show how Midjourney's website really works under the hood. This information goes well beyond the four corners of the complaints and cannot be considered on a pleading motion. For purposes of this motion, the court must accept that the Explore page operates exactly the way it is alleged to operate in plaintiff's complaints. Yeah, this is legalistically clever, but they're making a few assumptions here. And I want to point out one thing towards the top where it said deliberately selected, there was a footnote. Yeah, they avoided using a word there. They said selected instead of curates. And that's kind of interesting because in the complaint, they use that word curates quite a bit to make it sound like people at Midjourney are deliberately selecting and showing all these like, ooh, if we show Minions, if we show Iron Man, then we'll get more clicks and stuff like that. That was the implication. They didn't plead it directly. They were letting that word curates do most of the heavy lifting. So Midjourney in their motion said that's not how it works. You can't just use the word curates and say you've pleaded the facts. You need another step. There's a step between return the results that users want and return these results because they're popular characters in film or television or whatever. Those are two entirely different things. And so in their footnote, they say, Midjourney expresses confusion about the word curates. There is nothing unclear about the word, and plaintiffs invite Midjourney in the court to use any general dictionary definition. Okay, how about Merriam-Webster, one of the most popular American English dictionaries? What do they say? What does curate mean? It's a member of the clergy. Okay, that's not where we are. We want the verb. Curate, curating, curates. To select the best or most appropriate for presentation. To select and organize artistic works for presentation. Curating exhibits, curating galleries. Ooh, how about this one? To select and organize articles, images, etc. for distribution or publication. The way TikTok algorithmically curates content for each individual user was also a wildly effective, even if unintentional, advertising tool. Well, how about that? It looks like the word curates includes algorithmic selection, not just deliberate selection. So what happened is that Disney used the word curates quite a few times in its complaint. And they just kind of left it at that. Oh, they curate the images. When asked what that means, they referred us to the dictionary. But the dictionary definition of curate includes algorithmic curation that doesn't require any deliberate act by any human being. If they want curate to mean something more than that, they should have pleaded it. Remember, they have to plausibly state a claim in the original complaint. So they need to specify what they mean by curate, and they've refused to do so. So, if I were Midjourney, I'd be looking at every dictionary I could get my hands on that includes an example like this and just pile them all up on the judge's desk. Look at here, Judge. They all say you can curate algorithmically. Alright, so the next thing they have is the CEO statements. These include allegations that recite public statements by Midjourney CEO David Holtz, which show that Midjourney intentionally stocked its service with the copyrighted material of plaintiffs and others, and made no effort to get the consent of any copyright owner, thereby purposely facilitating the distribution of infringing outputs. You see what they're doing there? They're kind of switching what they're talking about very sneakily. They're talking about the sources that they used for the AI training, but then just in the middle giving you whiplash by talking about the outputs. Those are not the same thing. Such evidence supports a finding that Midjourney acted with an intent to encourage infringement. So what happened is they actually went out looking for all sorts of images that they, under fair use, could use for training. That's where the fair use comes up. They keep saying throughout this thing, I'm not really going over that part of it, but they keep saying, oh, fair use has nothing to do with this. Well, they're talking about selecting copyrighted images for training data. That's where the fair use comes in. So selecting copyrighted images to train on is not inducement of the users. That's just how you're making the model to begin with. Inducement means you have to encourage the users, not just make the tech. Ooh, and they tried to hide what they were doing, Your Honor. They were being sneaky. They were concealing infringing activity. As soon as this lawsuit was filed, Midjourney modified its Explore page so that certain searches for infringing works produced a response message that inaccurately stated nothing to see right now, even though infringing outputs were still stored on Midjourney's servers and available for distribution. Wait a minute. So you complained that they were showing your copyrighted images in the Explore page. In response, they filtered out your images. And then you're using that against them? You know, judges don't usually like it when they pull crap like that. That's not evidence that Midjourney did anything wrong. That's evidence that someone filed a lawsuit against them. And they don't want to compound the damages in case they lose. That's all that means. This change not only confirms that Midjourney is capable of implementing measures to prevent users from searching for infringing material, which is irrelevant because Cox says that doesn't matter, but it also shows that Midjourney has taken affirmative steps to conceal the infringing activity facilitated by its service, conduct that constitutes independent evidence of inducement. No, it doesn't. Because that's not enough under Cox. It's not even enough under Grokster. Failure to filter out is not inducement. Failure to take active steps can never be inducement. They were very clear on that. Oh, but they're secretly serving up their infringing outputs. When a subscriber now inputs a prompt that refers to one of the plaintiff's copyrighted characters, such as Superman or the Minions, the output is displayed only to the user, and the user is notified with a message stating, "Our filters detected potential third-party content, so we are keeping this generation private to you." In other words, Midjourney is recognizing and expressly acknowledging that the user has requested infringing content and that an infringing image has been generated and will be made available to the user just surreptitiously. In effect, Midjourney is telling the subscriber, "Here's some infringing content. We're happy to provide it to you in secret since it's illegal. Do you still want it?" No! Wrong! Because as far as Midjourney knows, they could be wanting to use it for a fair use purpose. Not all copyrighted outputs are infringing. And at any rate, this still isn't inducement. It's the user requesting it. And let's see, plaintiffs' allegations about Midjourney's business model also support inducement. In Grokster, the Supreme Court explained that a company's business model can be evidence of inducement, and other courts have followed this precedent. Yeah, but all the ones they mention are Pre-Cox. Because Fung is Pre-Cox, Arista Records is Pre-Cox, all the ones they're saying are Pre-Cox. Midjourney's failure to implement technological means to prevent infringement further supports infringement liability. No, it doesn't, and Cox was really clear on this. There's no possible way you could misread Cox in order to think that that is a form of infringement. Because that was one of the things they said. They said that Cox could have used filters on the BitTorrent protocol or whatever. No, none of that matters. None of that matters. Plaintiffs have sufficiently alleged that Midjourney's acts of inducement are likely to cause infringement. Again, not good enough. Not under Cox. Not now. Likely to cause doesn't matter. Knowing it will cause, not good enough. Knowing that it's actually happening, not good enough. Failure to stop it, not good enough. Having the ability to stop it and not doing it, not good enough. And you know, I can't help but notice this. One of the things that they're not doing is quoting from Cox. If I thought that Cox was on my side, I would be quoting Cox all over the place. I mean, notice Midjourney did. Yeah, they don't quote Cox one single time. They reference it here and there, but never quote from it. I think that's telling. And yeah, that's it. For all the reasons set forth above, which are not good reasons at all, plaintiffs request that Midjourney's motion be denied. Signed, all these ambulance chasers. Yeah, it's going to be interesting to see what Midjourney's reply is. But I started thinking, like, if I were Midjourney, what would I say? Admittedly, Midjourney's lawyers are a lot smarter than I am. But here's what I would say. Here's what I would put in my reply. The complaint does not define what curate means, and when plaintiffs were given the opportunity to clarify, they declined to do so, simply referring the court to any general dictionary definition, and reference the footnote. But the plaintiff must plausibly allege facts showing that the alleged curation affirmatively encourages infringement. Instead, the complaint merely alleges that Explore displays infringing images and expressly characterizes that display as evidence of Midjourney's knowledge. And then quote the original complaint, this curation demonstrates Midjourney's specific knowledge that its image service reliably reproduces plaintiff's copyrighted works and shows that the reproductions are extremely high quality. Cite the complaint, page 88. Under Cox, knowledge is insufficient. Plaintiffs cannot convert a conclusory verb that they refuse to define into the missing affirmative act. I imagine they'll say something along those lines. I mean, it'll probably be a lot better than what I said. And of course, they'll have a lot more to say as well. They'll be a lot more thorough than I've been. They're not going to let much go by. I don't really see, I don't understand. Why would you file this? After seeing what Midjourney did and what they pointed out about Cox, unless you're just figuring the judge is going to be corrupt and on your side, if you've got in any way a neutral judge, how would you expect them to be swayed by this? You're saying that it's inducement for all of the reasons that Cox says is not inducement. You just say that, Cox doesn't do this or Cox doesn't do that, but then you don't quote Cox even once. I don't know. How is this supposed to convince anyone who is being at all reasonable? I don't get it, but we'll see what Midjourney has to say and then ultimately what the judge says. So just to remind you about the scheduling, Midjourney's reply is due by August 25th. And then the motion hearing on this is October 5th. And then at some point, the judge may decide no motion hearing is necessary and just go ahead and rule, or there may take some time after that for him to rule, who knows. But I'll let you know. Yeah, thank you so very much for watching. Comments for the Comment God, shares for the Share Throne. Please hit like, subscribe, and the bell, and of course, donate.bogosity.tv. Keeps me doing this, whether it's one-time donation or regular support. Thank you so very much for watching. Until next time, stay strong and be free.